Wellesley-Weston Lifetime Learning offers non-credit courses to seniors in the greater Boston area. For more information about WWLL and links to our videos, please go to www.lcourses.org.
So this morning's speaker is Steve Lowe. Probably a certain number of you know him because he's been teaching here for, I don't know how long?
5 years.
5 years now. And he's been talking about various Supreme Court cases. I took his course and thought it was really fantastic. Steve is a graduate of Boston College and Trinity College. And he taught at Wayland High School for 10 years, was it?
10 years.
Taught French there. Actually, he's a man of a variety of interests. He taught French, and he produced a radio show of music and news that was very popular. He's published 3 books. And to quote him, once a master of French grammar, I became an expert in understanding Medicare regulations at Dana-Farber Cancer Institute and Metro West Medical Center. So that was another thing that he did. And since he retired, he decided to devote his time to his main love, which was the Constitution and the Supreme Court. And he's, as I said, taught several courses here, and he's very dynamic and enthusiastic, and I think you'll enjoy his presentation. So let's welcome Steve Lowe.
Thank you, Marianne. Thank you. It might seem a little odd that this career grasshopper is going to address you today about positions that are lifetime tenured. We're talking about the Supreme Court, talking about the Judiciary Department. You know, our government's divided into 3 different baskets. Executive, we won't be talking about him today. Legislative, we'll be going about our business in the legislative department tomorrow. But today, it's the judiciary, specifically the Supreme Court. What it does, who are these people that are doing it, what's their power, what's their limits, and a little bit of the history of some of these characters. Also, I'd like to go over the current Supreme Court justices. You might need to review who they are. They're always wearing the same clothes. They're not as colorful as people in the other branches, but they certainly are extraordinary people. I'll tell you more about them and some of the trends that are in place in the Roberts Court. John Roberts, you might be surprised to learn, has been Chief Justice for 15 years. It seems recent, but it's been a whole block of time so far. And a lot of changes have come his way and our way. There are 3 things that are citizen duties in this country. Not one of them is particularly specific to the Constitution. There are 3 things the government asks us to do: pay taxes, register for jury duty, and vote. Now, 2 of those contain penalties if you don't do it. Voting's the only one that won't penalize you individually. But collectively, you'll suffer if you decide not to. But you're not going to be fined. You're not going to be imprisoned. Your rights won't be taken away. That's why it's so precious. You have to want to do it. Now, I'm talking to the wrong audience if I have to mention any more about voting. We all know how important tomorrow is. It's the people's turn to be the jury on the representatives. How have you done the last 2 years? And we'll see. We'll see how it goes. I'd like to mention a quote I came across recently that has to do with voting, and then we'll move right to the court. This is a quote from Alexander Hamilton, the Federalist Papers, number 21. He said the natural cure for an ill administration in a popular or representative constitution is a change of men. One sentence, and it describes it. He said that in 1788. It is a change of men. In fact, what might be memorable about the Trump era is how many women are in public office. The rest will be footnotes. If it's a revolution, we'll see if it started for real, for true. How many women are on the Supreme Court? Do you remember? The current Supreme Court? 3. Who are they now? 2 of them are recent additions to the Supreme Court. Ruth Bader Ginsburg, Elena Kagan, and Sotomayor, Sonia Sotomayor. There's one other who was appointed by a Democrat. Who was that other man? Stephen Breyer. The rest are all appointees by Republicans. Do you know who those people are? Who's the oldest one? Who has the most tenure on the Supreme Court? One more. A very important current issue is voting rights. Court. Thomas. Do you remember whose seat he took? Clarence Thomas. A long time ago. You'll remember the name. Thurgood Marshall. Boy, have times changed, huh? Ooh, there are a lot of twists and turns in this, as there are in history, and it's sometimes reflected in the Supreme Court choices. When Thurgood Marshall, from the civil rights days of the mid-30s to when he became Solicitor General under Lyndon Johnson and the first black Supreme Court justice, I forgot what I was going to say. Oh yeah, the spread of time, the changes that come with it. You couldn't find a more opposite person than his replacement. Who else? Who else is on the Republican-appointed side? You got Clarence Thomas. Well, the recent one, Neil Gorsuch. Who's more recent than that? Brett Kavanaugh. We all know Brett Kavanaugh. He hasn't even got started yet, and we all know who he is. Alito, Justice Alito. One more. One more. A very important current issue is voting rights. Well, Roberts, of course. Are we missing anyone? I think that's it. That should be 9. That's 9. The other thing about that group, whether appointed by Democrats or Republicans, they only came from 2 law schools, Harvard or Yale. Isn't that something? Nobody planned it that way, but it's a real specialized shop. What does that mean? What do you suppose that means if they all went to the same law schools? 5 of them to Harvard, 4 of them to Yale. It means they had the same textbooks, the same professors. They are there and they stay with tenure as well. The other thing about them, they're all lifetime career federal judges. All they've done since they graduated from law school is read briefs, is read decisions made by a lower court. Not to detract, that's very important, but that's the only law they know. So they are expert at it, but that's what they've done. The only exception is Elena Kagan. Elena Kagan was Solicitor General under President Obama. All the others are federal appeals court judges. So they were doing that for years and years and years, and finally went to the top of the class, where the day-to-day work they do is the same as before. Listening to both sides, studying the Constitution, and making their decision. Remember, their decision is not like a presidential executive order. They just have one vote. What's been happening to those one votes over the years, over the recent years? When they do come to make their votes, what does it usually come down to? What's the vote split? 5 to 4. 5 to 4. This bothers John Roberts because he said, we need authority to make these decisions. He's speaking to the public. They need to know we're on board with this. 5 to 4 gives them a chance to wonder. Well, 5 to 4 is a split we've had for a long time, isn't it? It used to be one person was, well, we don't know how he's going to go. Remember, who was that justice who just retired? Kennedy. So that was the only one the networks would interview. It was all, we knew all the rest were going to go. How about you, Anthony Kennedy? And sometimes he'd go to the one side, sometimes to the other. You'd never know. He enjoyed that. He also wrote more of the recent decisions than any other justice. Roberts is taking over that role now. What I've discovered of great interest in the Supreme Court is if you know any names of other Supreme Court justices, not current ones, here are some Supreme Court justices who never had any federal judicial experience. Louis Brandeis. Oliver Wendell Holmes. William Brennan. Whizzer White. And a man named Jim Burns. Raise your hand if you remember Justice Burns, Jim Burns. Probably not. He was a Supreme Court justice and Secretary of State in the chaos of World War II. He never graduated from high school. He was governor of South Carolina. He was a helper in the New Deal days. And he was appointed for a year to the Supreme Court. You don't hear much about him. But of course, he didn't even go to law school. He was a kind of a placement. And then when George Marshall was taken out of the Army, he became Secretary of State for about half a year. Remarkable person. No one's ever heard of him. In South Carolina, I think there's a highway marker to poor Jimmy Burns. Potter Stewart never had a federal experience in the court system. Sandra Day O'Connor, she was Attorney General in Arizona. Stevens, John Paul Stevens, never had federal experience before he went to the court. Charles Evans Hughes, governor of New York, no federal experience. And William Rehnquist, in more recent times, nope. Not so today, that's my point. All these people had no experience in the court system. The ones we have now, that's all their experience. I'm not sure what that means yet, but they sure are specialized from the same factory, it seems. I don't know how that reflects in the decisions. In the 1954, there was the famous court case of Brown versus Board of Education. You remember that. Schools, north and south, no longer could be segregated. Desegregate your schools. It took 12 years to comply, but they finally did throughout the country. These people from the Warren Court never had federal experience. Hugo Black, he was a traffic judge in Alabama before being a senator. Earl Warren, he was never a lawyer. He was governor of California. Douglas, Jackson, and Frankfurter. or other members of the Supreme Court that never had the experience the current justices have. It used to be a more diverse group, is what I'm getting at. It used to come from all kinds of we the people. Now it doesn't. These are real specialists. Is that to our benefit? We don't know yet. We hope. Justices are accountable to public opinion. I wonder if I need to explain that any further. The president has his electorate, those who support him and put him in office. The congressmen have their folks back home. They're accountable to them every 2 years for Congress, every 6 years for the Senate. Believe me, a senator doesn't care much about public opinion except for that 6th year. It doesn't matter. Say what you want. I'll see you at election time. I'm going to move to some cases in a few minutes. I'm going to invite you to answer yes or no and think about some of the issues that we've been facing recently, over the recent years, and see where you stand. It's a little exercise in judicial temperament. These are cases that have already been settled, and once they're settled, they're not placed in stone, are they? But they become what's called precedent. Are you familiar with that term? Brown versus Board of Education, for example, was a very bold Warren court. That was his first case, incidentally, with no federal background. That was unanimous. Amazing, huh? Amazing. But he said, I'm not going to push it forward. We're not going to vote on it or decide on it unless it is unanimous. It's that sweeping. He understood that. And it was. Remember the resistance back in the 50s? Eisenhower was the one who sent in troops to Little Rock, Arkansas, remember? To enforce it. To enforce it. It was non-compliance for a long time. And even after the troops left Little Rock, the school was closed rather than be desegregated. It wasn't easy. That's one thing President Eisenhower mentioned in his memoirs. That was his worst mistake. Why did I put Earl Warren on the court? Because something else was happening too in those years, if you remember. Earl Warren is supposed to be a safe, conservative justice, appointed by Eisenhower, by the Republicans. But once in office, maybe it was his governor's background, I don't know. He didn't have anything to fall back on through the federal system. He just was part of that unanimous decision that said, yes, it's time. The schools must be desegregated. Eisenhower said, oh boy, not only that, but the criminal justice system was turned upside down by the Warren Court. Do you remember? The Miranda case, the Miranda warnings, imposed by the Supreme Court on every courtroom in the country. Woo! Sweeping power. Never anticipated. Before I get to those cases, let me read to you, if I may, from an expert in American history, Alexis de Tocqueville. Are you familiar with that writer? A French nobleman in the 1830s came over to the United States and said, I wonder how their revolution is working. Ours led to violence, to a dictator, to war. Yours seems to have been a little smoother. I wonder why. Well, he made a tour, a 2-year tour in the 1830s, before the Civil War. And this is what he said about the American judiciary. The peace, the prosperity, and the very existence of the Union are vested in the hands of the 7 federal judges. 7 at the time. Without them, the Constitution would be a dead letter. The executive appeals to them for assistance against the encroachments of the legislative power. The legislature demands their protection against the assaults of the executive. They defend the Union from the disobedience of the states from the exaggerated claims of the Union, the public interest against private interests, and the conservative spirit of stability against the fickleness of democracy. Their power is enormous, but it is the power of public opinion. They are all powerful as long as the people respect the law, but they would be impotent against popular neglect or contempt of the law. That's a curious thing about the constitutional treatment of the judiciary. They have no enforcement power. They count on the president to enforce the decisions they make. That's what sent federal troops to Little Rock. It was noncompliance. You must comply. It's the law of the land. Let me ask you a couple of questions having to do with issues. I'm going to ask, it's yes or no questions, just as you remember, as you recall, or as you want to respond. Just raise your hand for yes or no to these questions. I'll do them one at a time, and then we can discuss them. May a state set limits on congressional terms? You've heard of term limits? May a state set limits on congressional terms? How many of you over here would say yes? Over here, how many of you would say yes? The answer is no. You're absolutely right. A court had decided that. Back in 1995, term limits can apply by state, but only for state offices, not for federal. You understand the split, of course. So when you're talking about term limits, it's already been established as precedent. It can change. Not likely to. That was a 5-4 decision as well. But no, the term limits, whenever it comes up, or people discuss it, or people get excited about it, it's not going to happen. Likely not going to happen. You see what I mean? An amendment could change it. But it certainly wouldn't affect those in office currently, because amendments take forever. How about this one? Must a state recognize same-sex marriage rights? Must a state recognize same-sex marriage rights? A famous case. How many of you would say yes? Just a few. How many would say no? Oh, you're going to be surprised. Must all states recognize same-sex marriage rights? Yes. There was something back in the 90s called the Defense of Marriage Act. Do you remember that? Oh, it's in the dustbin of history now. But Congress was intent on it. This law said marriage is between a man and a woman throughout the country. Well, that lasted until 2013. Another 5-4 decision, U.S. versus Windsor. Now, you don't remember that, I'm sure. The names don't come to you with cases. But this was the famous case of a same-sex couple in New York State. One of them died, and the estate went to the other person for New York state taxes purposes. The federal government sent them another bill. Federal government taxes. We don't recognize your marriage, said the federal government. That's what caused the case to come to the attention of the Supreme Court. And their 5-4 decision in 2013 was in favor of Mrs. Windsor. She did not have to pay the federal tax. Treated just like any other spouse, any other estate. That's the power of Amendment 14, the one that affords equal protection. You can't just carve out a certain group and say it doesn't apply to you. It applies to everyone else. That's what makes Amendment 14 so powerful. One more, a very important current issue is voting rights. Yes or no? Can a state change its voting laws without federal approval? Can a state decide to change its voting laws without checking with the government? How many would say yes? Good. How many would say no? Well, the answer is yes. Yes. As of, where's my date here? 2013. This is a famous case, 5-4, called Shelby County versus Holder. And what it means is, because of the Voting Rights Act of 1965 under Lyndon Johnson, certain states were highlighted as being troubled spots, mostly in the South, with their limiting voting access. And they kept track year after year after year, and there was certain improvement. Well, the Supreme Court, specifically John Roberts, saw a great deal of progress in that and said, you know what, it's not fair to punish them anymore. Let's get them out of the penalty box. So now, if a state wants to change its rules for voting, it may do so. Before that, the Department of Justice would come in and say, no, you can't do that. No, you can't do that. But only for those troublesome states. And that was the point. Once again, this time it wasn't Amendment 14, it was Amendment 5. The federal government cannot do that. Discriminate without a good, defensible reason. It's a concept called, sovereign equality. If the states are going to be told what to do, it must apply to all of them, unless there's a good reason. So that one is yes, that's true. They can change their laws. In fact, they're doing it, aren't they? Certain states, as soon as this decision came out in 2013, said, great, we're going to change our laws. No Sunday voting. No voting the same day you're registered. No registration by mail. All kinds of restrictions as the people who design it want. Who are the people who design it in the state? The voting laws. The legislature. The representatives and senators in the state. They decide, based on the input from their constituents, what would be fair to their constituents, their state, about voting. And it's changing all the time. That's what makes it so confusing. When you get election results, either in a presidential year or in a off-year election, excuse me, it makes it very confusing to find out that Illinois' rules, oh, they're different from Massachusetts. Oh, that doesn't apply to Nebraska. Voting has always been in the hands of the states. That's what's made it a tough legal issue when it comes to the Supreme Court. But this one's been decided. Want to do one more? Yeah? Question. Oh, about executive orders. Can a presidential executive order deny entry to the U.S. to travelers from certain countries? Can the presidential executive order deny entry to the U.S. to travelers from certain countries? How many would say yes? How many would say no? It looks like 5-4. It was again 5-4. The answer is yes. It happened in Trump versus Hawaii last year. You might not remember the title or the issue. That's the Muslim travel ban, remember? And the Supreme Court, 5-4, said, wait a minute, the president is in charge of national security. If he says these are dangerous countries and doesn't want to go into the details, I think we might as well err on the side of caution. It's a First Amendment issue. It didn't show anywhere in the record that there was any animosity toward the Muslim religion in what was presented to the court. All right? Let me say that again. It doesn't matter what the president was tweeting, what was in the papers. What was presented to the Supreme Court under the First Amendment was, I don't see anything here that says it's Muslim. It's based on the countries. And furthermore, a majority of the court said the president needs to be given deference here. He's in charge of the national security. He knows more than we do. He's commander-in-chief. Okay, that's a little walking on thin ice, isn't it? Because there was a case during World War II after an executive order. Do you remember the one called Korematsu versus U.S.? Rounding up Japanese Americans and putting them very quickly in concentration camps by executive order. The Supreme Court at that time said the same thing using the same reasoning. We can't tell whether these people are loyal or not. I know they're American citizens. I know they have certain rights, but we're going to take their property. We have to. Oh my goodness, it's a time of great danger. We don't know who's loyal. The only way we can tell is if we can interview them. We can't interview them individually. Lock them up. It was a disgrace, of course. It's been acknowledged as a disgrace by the Supreme Court, by every politician you could think of. Do you know who was Attorney General during that era, 1944? Earl Warren. Later Supreme Court Justice, Chief Justice. That's very good. That's very good. It splits usually because the country is split. I don't think it's ever been this divided since before the Civil War. So many things we couldn't resolve. The abolitionists from the North, the settlers in the West, and the planters in the South. Not going to change our way of life. I'll die before I'll let you do that. Well, it took a civil war to settle that. Didn't take the Supreme Court. Except the Supreme Court came along and did make a decision before the war started. It was called the Dred Scott case, Scott versus Sanford. And it said, you know what? We're going to do this country a favor and define what a slave is. A slave is property. Has no rights. Denied. And shortly after that, abolitionists weren't talking to non-abolitionists. North wasn't talking to South. And it led to violence. We had to go through that. It took a civil war. It took how many years? 4 years? I lose track of how long wars take. We're currently in one that's 17 years old. But that was 4 years. I think it took 700,000 lives. We couldn't settle it any other way, it seems. Otherwise, we're very proud to be a land of laws, where no one's above the law. Everyone is subject to the law. There's a group of 9 people that say what the law is. Article 6 of the Constitution mentions that. Whatever they decide is the law of the land. It will apply to everyone. No exemptions. It's a powerful body, isn't it? The court itself. They're as I say, they wear the same uniforms. But they are a political body, too. Don't make any mistake about it. They're appointed by politicians for political reasons. They're expected to follow the party's agenda. Sometimes they do, sometimes they don't. Because remember, they confer among each other. They still watch CNN. They still go to political fundraisers. They still go to cocktail parties. And they talk, and they know just what we know. But when it comes down to making a decision, they're in a room with their colleagues. And they know the importance of the decision they've decided to make. It's considered. It's not frivolous. There's a reason behind it. But woe to them if it's against public opinion. Sometimes it takes a while to catch up. An example would be same-sex marriage. That was public opinion pushing the court. What I mean by that was, while they were deciding whether they should take the case of Obergefell versus Hodges in 2015, state after state was already passing laws. So they said, well, let's hold back and see where it goes. Why should we go against that wave? What would be the consequence? Massive noncompliance. They can't enforce it. Let the states do it. In a kind of a hidden way, in a quiet way, that's what's happening with the federal law against marijuana. Colorado says, the heck with that. We need the money. We need the income. That's still unresolved, isn't it? It's a state law, and you can sell it, manufacture it, and make money from it. Federal law, it's against the federal law. The point is, Attorney General Sessions is much too busy with other duties to enforce the marijuana laws of Colorado. However, there are Supreme Court cases burning, state after state, because neighboring states are saying, we can't keep up with the highway patrolmen we need that leave your state with marijuana to sell somewhere else, and it's illegal in our state. Hasn't been decided yet. It'll be one of those yes-no questions for future audiences. I don't have any idea what this particular court that I highlighted earlier, I don't know what direction they're going to take us, but it won't be reckless. There's a structure behind them. There's a tradition behind them. And public opinion is always their boss. Not so for legislators or executives. But for Supreme Court justices, they understand the weight of their decision. They're the ones who know before the day it's announced, oh boy, it's another 5-4. And what they'd love to do is say, oh great, it's a 9-0. Well, are there any 9-0s today? Yes, but they're on things that are quite trivial. Things that matter to certain people, not the whole country. Those are unanimous. I can't think of the last one that went 9-0. There are all kinds of issues that are still boiling out there in the stove. Gerrymandering. Oh boy. One of the oldest traditions in our country. Once again, the state legislatures design the districts. And they get to do it every 10 years. Oh, good. My friends would like it this way. Let's do that. Remember Barney Frank? Poor Barney Frank. When they when they changed his district, he was going from Newton now to Fall River. And he said, my God, I don't know anything about fishermen. Yeah, but that happens. The Supreme Court isn't there to make sure these are all fair. The Supreme Court isn't there to decide what's fair or not. It's there to decide whether it conforms to the Constitution. And on what basis? What article? What amendment? They don't want to make our lives better. They didn't decide the case on Obamacare in the favor of Obamacare because it would help people. It's because Congress has the power to raise taxes. If you don't comply, you've got to pay a tax. That's the only thing they used to defend that, as they were guarding the Constitution. Wherever it works beyond that, that's for the politicians to handle. But remember, they're political people too. Sandra Day O'Connor, you may have heard her speak out recently. She's spoken out over the years about how disappointed she is in her party. in the politicians, in the Supreme Court appearing more and more partisan. Do you remember seeing that in the hearings for Kavanaugh? There are two agendas in the room: our friends and our enemies. It was everywhere evident, wasn't it? I don't know how you prevent that. People are behind those robes with an important job to do, but they're people. Let me ask if there are any questions you may have on anything I've talked about or left out. Marion is going to pass the microphone among you, and I'll be happy to address them. Any questions?
Steve, didn't one of the current justices graduate from Columbia?
Yes, Alito. Yes, Justice Alito. Let me check. Cornell. She was from Cornell. Yes.
And moved to Columbia because her husband was in.
That's right. That's right. Yeah, that's true. That's more accurate. Mm-hmm. Yes, Bruce.
Steve, you mentioned at one time there were 7 justices on the court, obviously 9 now. Where is it specified how many justices are on the court, and or how do you change the number?
Good. In Article 1, the authority to change the Supreme Court in any way is up to Congress. Congress makes the rules for them. And it got to the point where the justices were saying, wait a minute, this workload is too big. My territory is growing as the population grew. So we have 7, now it's 9. It could be more. I don't know why it would need to be. It's an enormous structure. There's the federal court in D.C. where most of the justices come from, and there are others around the country, the Northeast, the Southwest, given a number. But it amounts to 9 now, and that's worked out well so far. Yes, sir.
I think I heard you say that the justices, once appointed by their party, are supposed to adhere to their party's tenets. Did I understand you correctly?
No.
Okay.
No, the party's agenda?
Well, I thought I heard you say that if somebody is appointed by a Republican administration, they're expected to, I'll say, hew the Republican line of thought. Was that your point?
Yeah, I think that's a reasonable interpretation of what I said.
I'm sorry.
Yes.
That was your point.
Yes.
I would respectfully disagree with that point.
Can you give an example?
Well, the reason I would disagree with it is because I'm a retired attorney and I did a lot of work in the appellate level. And in my experience, it was very hard after 2 or 3 years to even remember what party these people were coming from. That they were more of a conservative bent on how the Constitution should be interpreted, Scalia being an example, or they were more a liberal bent. And sometimes it was very hard to figure out how they were going to work out. Kennedy, for example, the one that just retired, started out as a very conservative justice and ended up being more of a moderate, and vice versa. So I think there's more to it, if I may respectfully submit. I think there's more to it, to a justice's position as he or she progresses, than just what party they've come from.
I think you're right. But all we know is what that person has done during his hearing. I mean, they know what kind of candidate they have. Do you see what I mean? And over the years, oh yes, cases can change his opinion, his outlook, sure. I didn't mean to not say that. Okay. Yes?
I agree with the man that just spoke, and an example, it's only been during our lifetime, like President Eisenhower appointed Justice Brennan, who was probably one of the most ideological justices in history, and certainly not a conservative. A lot of the 5-4 decisions started in the 70s under Justice Brennan. Under his guidance, they voided 15 constitutional laws. So he was a very aggressive judge, very liberal, and I don't think that was, so I don't, and I would say the same thing about Justice Warren, Justice Berger. I don't think that, it may be coming true now, but I think there's been a lot of cases where the justices have acted independent of what the ideology of the party has been.
Well, I don't know how to respond to that. I don't know what your point is.
No, I just don't think that you're right that to say that a judge appointed by a Republican president is going to vote Republican or conservative, I don't think is substantiated over the course of the history of the court.
Oh, I don't mean to say that, no, it's not that predictable, of course. But there's a reason he was appointed by that person and supported by that Senate, with the hope that over the years, their agenda will continue in some form or another. Does that make my position any clearer? I don't know. I have trouble with labels like Brennan. I don't know his whole career. I don't know how he came into the court with a label. I don't know what it would have been. His decisions could have made him easily labeled liberal, radical. I don't know. Yes?
You indicated that Justice Roberts validated the Affordable Care Act because of the ability to raise taxes. When Congress recently passed, I assume raising taxes, the penalty clause?
Yes.
And now that's been ruled no longer available or no longer in effect. Does that mean the Affordable Care Act is at danger because that justification when it was ruled legal no longer applies?
Well, yes. It was also ruled legal, valid for the Supreme Court's purposes when it had a mandate, an individual mandate. That too has changed. A little by little it's shredding, but it hasn't been replaced. They're in the process in Washington of repealing it piece by piece. But that basically was whether the individual mandate could stand. And the answer was yes, based on the Congress's power to tax. Remember, that was a Democratic Congress for a brief time. And that was unanimous without a single Republican vote. That was the determination of the Congress at that time. And the Supreme Court said, okay, that's what you did. That's the way it stands. But there were arguments on the other side, too.
Is it illegal now? Is the Affordable Care Act now been, by definition, since that mandate is removed, does the Affordable Care Act disappear?
No. No, it's not in its original form. No. And it seems to be like it's leading toward state leadership. I think that's where it's going to go. The states are going to somehow have their own, the way Massachusetts has its own. But for the most part, it's still in effect. There's legislation coming up next year to change certain things in there. Coverage for this, what's it called, the continuing coverage. Certain things will stay, certain things want to be taken out, and it'll be renamed. Mm-hmm.
I have a question about the state's right to change voting laws. In the South, many black votes were suppressed for various reasons. One was because some people didn't have a definite address. If the federal government were in charge of setting these rules, wouldn't that have been eliminated?
I suppose so. I suppose so. I don't know what circumstance would arise that would make the federal government.
I'm sorry?
I say I don't know under what scenario that would be possible. For the federal government to decide?
Well, I'm saying it's not right to suppress votes of a certain group of people, and I just don't see the state doing that, having that right to do that. If the federal government set the rules for the voting, that wouldn't happen.
That's correct.
So why are the states allowed to do that?
They've always had that right. That's always been their territory. Nope.
That's all.
No. I'm sorry, there's no answer. I don't think it would ever happen that the federal government would take it over or want to. But Congress will pass a law that says this is what we'll do, and then either repeal it or overturn it or change it in some way. But no, that's up to the states. And that's always a balancing act too. States and federal government.
Okay, one more question, and then we'll have to end this.
What is your opinion on the damage to respect for the Supreme Court's objectivity? Because there's been so much focus by both parties on who gets to stack the court, so to speak, by which both parties are saying, if we get to a point, our agenda will be, hopefully, by the parties, advanced. And there may always have been a myth that the Supreme Court on political issues is objective, but that myth, that bubble has been so burst. So again, my question is, what's your opinion on the impact of the respect for the institution?
Well, I think it's always, it's always favorable, generally, by the public, seen by the public as favorable. But there was a time in our history when every decision they made favored the railroads, never the workers. They'd throw out an injunction against union activity like that for years and years, and that would be okay, precedent upon precedent, because we have to think of business, and that was their stance. Business, the railroads, the steel industry. No, we have to. Our decision is based on what's best for the economy, best for the country, wherever that stance came from. So I don't see how they could be objective. That's a tough word, objective. They can't place themselves out of the context of what the issue is or the times are. I don't know whether what we have now is more political or less political than it's ever been. It becomes more evident at certain times. Remember, technology is out there churning all kinds of changes. A lot of the stuff we know today within minutes previously was hidden from us. How many of you ever knew that John Kennedy was suffering from a disease? Oh, is the doctor in the house? Yeah. No, things that were hidden before are now way out in the open. So I don't know who can be objective. It's a little bit like, I don't know who can be a criminal today because there's a camera everywhere. But we haven't solved burglary. Yeah. These are very good questions. And I hope I haven't confused you. But there's often a tangle involved here. These are all issues that are very important. The decisions are individual, but they have great effect, like fingers out there, that change things, maybe not right away, but in the future. We don't know what's going to happen next. Thank you for not asking me a question about what I think they'll decide on this or that. I don't know. I know what their agenda is like, what they're deciding now. In fact, you can find out, there's a wonderful website that'll keep you informed of what they're studying before the decisions come out in the summer. It's called constitutioncenter.org. One word, constitutioncenter.org. It comes out of Washington. And it will give you, as often as you like, information on what they're doing and other topics about the Constitution, and specifically about the court. That's a very handy website. I recommend it. Thank you for being so informed. Thank you for continuing being informed. Good luck tomorrow.
Thank you, Steve, for coming. Thank you very much.